Hello everyone, let's begin our new series. Question number 502. Per use used in a subsection 4 of section 164 of Bnss means to go through critically, that is to read attentively the documents and affidavits by one. Option B, to go through critically, that is to examine critically in detail the documents and affidavits one by one. So here correct option is option C, both A and B. Question number 503. What is incorrect in the object of section 163 of Bnss? So option A is it seeks to enable the police commissioner to prohibit march, drills or training with arms in public places. Option B, it seeks to enable the police constable to prohibit march, drills or training with arms in public places. Option C, it seeks to enable the government employee to prohibit march, drills or training with arms in public places. Option D, it doesn't seek to enable the district magistrate to prohibit march, drills or training with arms in public places. So correct option is option D. Question number 504. Section 164 of Bnss deals with the jurisdiction. Option B, the mode of taking evidence. Option C, grant of course in respect of proceedings initiated under 163, or all of the above. So correct option is option D, all of the above. Question number 505. In which of the following cases it was held that section 164 of CRPC, now 183 of Bnss, is required to be strictly complied with? So here correct option is Bhavai Udenish Odesin Parmar versus State of Gujarat. Our next question is in which of one of the following cases section 164 of Bnss does not apply? Option A is where a party has a property in dispute. Option B, when two parties are in joint possession of the property in dispute and both of them try to evict each other, endangering public peace. Option C, when two parties are in joint possession of the property in dispute and one of them tries to evict the others to endanger the public peace. Option D, none of the above. So correct option is option C, when two parties are in joint possession of the property in dispute and one of them tries to evict the other to endanger the public peace. Question number 507. In which of in case in case a civil suit is in respect of the same subject matter is pending criminal court is not brought from exercising jurisdiction under. So here correct option is option C, section 164 and 165 of the Bnss. Question number 508. In which one of the following cases section 164 of the Bnss does not apply? Option A is when a party is in possession of a property in dispute. Option B, when parties are in joint possession of the property in dispute and both of them try to evict each other, endangering public peace. C, when two parties are in joint possession of the property in dispute and one of them tries to evict the other to endanger the public peace. So here correct option is option C. Question number 509. A magistrate can appoint a receiver in case of dispute property under A, section 133, section 144, section 145, section 165. So option D is correct, 165. Question number 510. The finding of a civil court is given under section 165 of Bnss in a reference by a magistrate regarding possession. A, cannot be challenged by way of appeal but it is subject to review and revision. B, it is not subject to review or revision but can be challenged by way of appeal. Option C, cannot be challenged by way of appeal, review and or revisions. Option D, can be appealed and is subject to review and revision. So here correct option is option C, cannot be challenged by way of appeal, review or revision. Question number 511. Under section 155 Clause 2 of Bnss in the event of receiver being subsequently appointed in relation to the subject of dispute by any civil court, the magistrate option A shall order the receiver appointed by him to hand over the possession of the subject of dispute to the receiver appointed by the civil court. Option B may make such other incidental or consequential orders as may be just. Option C both A and B. Option D none of the above. So here correct option is option A shall order the receiver appointed him to hand over the possession of the subject of dispute to the receiver appointed by the civil court. Question number 512. What is the scope of section 166 of the BNS? Option A is it is not limited in its terms of easements but relates to any dispute concerning the right of use of lands or water. Option B, it does not enable a magistrate to make a purely declaratory order. Option C, jurisdiction of a magistrate to act under this section ceases as soon as a competent civil court has adjudicated upon the matter in dispute. Option D, all of the above. So here correct option is option B, it does not enable a magistrate to make a purely declaratory order. Question number 513, whether suspicion is option A substitute for proof of offence, not a substitute for proof of offence, a relevant factor for proof of offence, not a dependent factor. So here correct option is option B, not a substitute for proof of offence. Question number 514, read the following. FIR is only a report about commission of a crime. FIR in itself is a substantial error. So we have to choose the true or false. So 1 is true but 2 is false. So here option A is correct. FIR is only report about the crime, commission of crime itself, not substantially evidence. What is the nature of statement given in a narco test? Not evidence, it is a scientific evidence, it is oral evidence, or it is a circumstantial evidence. So here correct option is it is a oral evidence. So option C is correct. 516 G, a 17-year-old girl was married to H. H during the subsistence of said marriage entered into another marriage with P. The court may take cognizance of offence bigamy if the complaint is brought by option A her father, mother, brother, sister, son, daughter, or by her father's, mother's, brothers, or sister. Any other person related to her by blood, marriage, or adoption with the leave of court. Some other person on her behalf with the leave of court, but where there is a guardian appointed in her respect, then only after such guardian has been heard. All of the above. So here correct option is all of the above. All of the above can file a complaint to a court. Question number 517, conditional order under BNSS for removal of nuisance can be passed by district magistrate, subdivisional magistrate, any other executive magistrate. So here all of the above is correct answer. L, the landlord in respect of one room house let out by him in favor of T was prosecuted on charge of house trespass after physical assault and causing simple hurt to T, and has been convicted for the criminal offence. It being so also proved to the satisfaction of a metropolitan magistrate that by use of such force T was dispossessed of the tenanted property, is permissible for trial court to order restoration of possession of T. Options are yes, but not more than 1 month after the date of conviction, yes but without prejudice to right or interest of the person in possession as may be established in a civil court. Option C, both A and B are correct. Option D, both A and B are incorrect. So here correct option is option C, both A and B are correct. Question number 519, a vagabond and a homeless boy aged 12 years is found running in the street, pushing away a cart full of bananas, and upon being questioned by police officer in charge of the subdivision is unable to satisfactory account for the same. There has been no repeat of the theft, but the police officer has reason to suspect that the same is stolen property. Option A. The police officer may seize the above said property. The police officer having seized the above said property may, with approval of the SP, sell by auctions the banana chips where value is less than 500 and report to magistrate, who may take sale proceeds at the disposal of state if rightful claimant is not found within 6 months. Both A and B are correct. So here C is correct, both A and B are correct. A group of militants of certain communal organizations conduct training of members with arms in public place, threatening public peace and safety. With regard to this, which one of the among this statement is correct? So the option is the police officer may pass order or public notice prohibiting conducting training with arms with the local limits of the jurisdiction. Option B, the judicial magistrate having jurisdiction over the area is authorized to pass any prohibitive order under the provisions of the Code of Criminal Procedure. Option C, the district magistrate may, if necessary, prohibit such activity for the preservation of public peace and safety by public notice or order. Option D, the district magistrate may direct the police officer within the local limits of his jurisdiction to pass a prohibitive notice or order for preservation of public peace and safety. So here correct option is option C, the district magistrate may pass, if necessary, prohibit such activity for the preservation of public peace and safety by notice or order. Question number 521. Executive magistrate can put a party in possession of immovable property. Option A, upon the police report, the dispute in respect of such property is likely to disturb public peace. Option B, if that party is dispossessed unlawfully. Option C, if the rival party denies to deliver possession of a property through such party is owner of it. None of the above. So here correct option is option B, if that party is dispossessed unlawfully. Question number 522. Any dispute relating to possession of immovable property according to the chapter 9 of Bnss 2023 decided by So here correct option is option B, executive magistrate. Under section 520, question number 523, under section 172 of Bnss, all persons shall be bound to conform to the option A, lawful directions of a police officer. Option B, directions of a police officer given in fulfillment of any of his duty. Option C, lawful direction of a police officer given in fulfillment of any of his duty. None of the above. So here correct option is option C, lawful directions of a police officer given in fulfillment of his duty. Question number 524. Under Bnss, where two or more courts have taken cognizance of a same offence and question arises as to which of them ought to try that offence, the question shall be decided by option A, by the Supreme Court. Option B, if the courts are subordinate to the same High Court, the High Court by the same High Court by that High Court. If the courts are not subordinate to the same High Court, the court within the local limits of whose appellate criminal jurisdiction the proceedings were first commenced. So here correct option is option B. 2 and 3 are correct. Consider the following statement and choose the correct answer with the help of Bnss given. First, investigation is conducted by a police officer. It's true. Second, the magistrate cannot interfere in the investigation. Option third, investigation is a judicial proceeding. It's wrong. investigation, not a judicial proceeding, is true. So here correct option is option B are correct. Option 1 to 4 are correct. Question 1526. In which of the following cases it was held that a person has a right to protection under 161 of CRPC, now 180 of Bnss, against a question which would have a tendency to a criminal charge? So here options are Nandani Saptapati versus PL Dani, Jian Singh versus State, Rupan Deol Bajaj versus KPS Gill, RK Dalmia versus Delhi Administration. So here correct option is option A, Nandani Saptapati versus PL Dani. Question number 527. Which of the following statements are true? Option A is inquiry means every inquiry including a trial conducted under Bnss Sanhita by a magistrate or court. It's true. It's not true actually. Inquiry means every inquiry other than a trial conducted so Sanhita magistrate. So here B is correct. A failed trial for cheating Z by dishonesty, inducing him to lend money by knowing alleging fake diamonds. Z died during the trial and was survived by a son. X moved an application in the trial court to compound the offence. Which of the following is the correct legal propositions? X is not competent to compound the offence. On the death of a complainant Z, the trial proceedings shall be obeyed. The court cannot entertain such application after the death of the complainant. Option D is X can compound the offence with the consent of court. So here correct option is option D. A criminal court at the conclusion of trial may order restoration of a possession of a immovable property to the person who had been dispossessed therefrom by use of criminal force or by criminal interpretation by the person convicted. Option B, the destruction of pornographic material in respect of which conviction was recorded. So here correct option is option C. Both A and B are correct. Period of limitation shall commence. Option A, from the date of the offence, generally from the date of knowledge of the commission of the offence if not known earlier. From the date of establishment of identity of the accused if it is not known at the time of commission of the offence, or all of the above. So here correct option is all of the above because of the options are correct. Question number 531. Which of the following pairs are correctly matched? So here definitions are given. We have to match it from the sections. Conditional order for removal of nuisance. So it is given in section 152. Service or notification order. So it is given in 153. Person to whom order is addressed. So it is given in 154. Penalty for failure of compliance. It is given in 155. So here 152 is given first. So first we can match with 2. Second we can match with 1. Third we can match with 4th. Fourth we can match with 3rd. So here the correct option is option B. 2, 1, 4, 3. Which of the following are pairs are correctly matched? So here the next question is procedure where assistance of public right is denied. So it is given in 156. Procedure where person against whom order is made under section 152. So here it is given in 157. Power of magistrate to direct local investigation and examination of an expert. So it is given in 158. Power of magistrate to furnish written instructions. So it is given in 159. So here correct option is option A. 4, 1, 2, 3. Which of the following pairs are correctly matched? So here also definitions and section. We have to match definitions from the sections. So first is power to issue order in urgent cases of nuisance or apprehend danger. So it is given in 163. Second, magistrate may prohibit repetition or continuance of public nuisance. It is given in 162. Procedure where dispute concerning land or water is likely to cause breach of peace. So it is given in 164. Power to attach subject to dispute 165. So here correct option is option D, 3124. Question number 534. So here dispute concerning right of use of land or water, it is given in 166. Local inquiry is given in 167. Police to prevent cognizable offence is given in 168. Information of design to commit cognizable offence is given in 169. So the correct option is option A. Which of the following pairs are correctly matched? Arrest to prevent commission of cognizable offence. So it is given in 170. Arrest to prevent commission of cognizable offence. Prevention of injury to public property. It is given in 171. Persons bound to conform to lawful directions. It is given in 172. 172. Information in cognizable cases is given in 173. So here correct option is option A. Chapter 8, information to the police and their powers to investigate. So it is given from section 173 to 196. FIR can be given by the accused also. If FIR is given by the accused, the same can be used. Option A is for the corroboration of the accused, for the contradiction of the accused, as an admission if the same is non-confessional, against the accused as a confession. So option C is correct, as an admission if the same is non-confessional. A and 4 of his accomplices who abscond are alleged to have kidnapped G from New Delhi, taking and confining her in several places at Gurugram, Haryana, where from ransom calls are made, then take her to Uttar Pradesh. After a week, her dead body bearing multiple antemortem stab wounds found at secluded spot in Kanpur. Cases are registered by police in New Delhi, Gurugram, Kanpur. A is arrested by Kanpur police and integrated recovery of weapon offence disclosure. The personal articles of G are recovered from Gurugram. The evidence is shared by the police in each state. Their counterparts in two states. Reports of investigation of such basis under 173 code are filed. By police seeking trial of A on charge by offence of kidnapping for ransom and murder in Kanpur, Gurugram and New Delhi. In that order, cognizance of each report having been taken by the jurisdictional magistrate summoning
A. As accused, the High Court of Judicature at Allahabad shall decide as to court at which place will inquire into or try the offence. Option B. The High Court of Punjab and Haryana shall decide as to court at which will inquire into or try the offence. The High Court of Delhi shall decide. Only court of Delhi can inquire offence. So here option A is correct. The High Court of Judicature at Allahabad shall decide as to court at which place will inquire into or try the offence. Because the murder is happened in Kanpur. If a person whose statement is recorded by the police during the investigation is called as a defense witness, his previous statement before the police can be used as to corroborate him, can be used to contradict him, cannot be used for any purposes, both handles. So here option C is correct, cannot be used for any purposes. Question number 539. The inherent power of court to order joint trial of cases is exercised when it appears to the court options are that some common questions of law or facts arises in both proceedings. Option B. The right of relief claimed thereof is in respect of the same transaction. The right to relief claimed thereof arises out of the same series of transactions. Option D. All of the above. So here the right option is option B. All of the above. Question number 540. Under the section 173 of Bnss on receipt of information relating to the commission of any cognizable offence which is made punishable for 3 years or more but less than 7 years, the officer in charge of the police station may, with the prior permission from the officer not below the rank of DSP of police, considering the nature and gravity of the offence, option A, proceeds to conduct a preliminary inquiry as to ascertain whether there exists a prima facie case for proceedings in the matter within a period of 14 days. Proceed with investigation when there exists a prima facie case. So here correct option is option C, both A and B. Question number 541. On receipt of a complaint before ordering an investigation by the police under the section 175(3) of Bnss, the magistrate has to see that option A, the complaint discloses cognizable offences triable by magistrate. The complaint discloses cognizable offences exclusively trial by the court of sessions. The court, option C, the court discloses, the complaint discloses cognizable offences irrespective of whether the same is triable by the magistrate or the exclusively by the court of session. The option D, the complaint discloses the cognizable offence only triable by the magistrate and not exclusively triable by the court of sessions, as it is for the magistrate to inquire himself into offences exclusively trial by the court of sessions. So option C is correct. The complaint discloses cognizable offences irrespective of whether the same is triable by the magistrate or exclusively by the court of sessions. So here question number 542 under the section 175 plus 4 of Bnss, any magistrate empowered under section 210 may, upon receiving a complaint against public servant arising in the course of the discharge of his official duties, order an investigation subject to. So option A is receiving a report containing facts and circumstances of the incident from the officer superior to him. Receiving a report containing facts and circumstances of the incident from the officer superior to him. So here both options are correct. So option C is correct, both A and B. In a non-cognizable case, the accused, options are, can object to grant permission under section 175 plus 2 of Bnss as a matter of right. Option B, can object to the grant of permission under section 172 and 75 class 2 of Bnss with the leave of magistrate. Can object to the grant of permission under section 175 plus 2 of Bnss with the leave of the High Court. Option D, has no right to participate in the proceedings and cannot object to the grant of permission under section 175 plus 2 of the Bnss. So here correct option is, has no right to participate in the proceedings and cannot object to the grant of permission under section 175 plus 2 of the Bnss. 544, question number 544, under Surakshya Sanhita non-cognizable cases are public wrongs, private wrongs, both public and private wrongs, none of the above. So here correct option is private wrongs. Question 545, a magistrate has the power to direct the police to investigate in respect of an offence. Options are under the Bnss, under any local or special law, both A and B. Only A, not B. So here correct option is both A and B, under the Bnss and the local or special law. Question number 546, leave to investigate a non-cognizable offence can be granted by magistrate. Options are magistrate in any part of India, magistrate in any part of the state, magistrate having jurisdiction to try the case, or either A, B or C. So here correct option is option C, magistrate having jurisdiction to try the case can be granted to leave to investigate a non-cognizable case. Question number 547, the word magistrate mentioned in the section 175 clause 3 of Bnss means a judicial magistrate, a special executive magistrate, or either A, B or C. So here correct option is option A, judicial magistrate. FIR suggests that options are, it is the earliest and the first information of a cognizable offence permitted by an officer in charge of a police station. It is the earliest, and option B, it is the earliest and the first information of a cognizable offence recorded by officer in charge of a police station. Option C, it is the earliest and first information of a cognizable offence committed by an officer in charge of a police station. So here correct option is, it is the earliest and the first information of a cognizable offence recorded by an officer in charge of the police station. So here option B is correct. Which of the following cases fall under the category of police section of the preventive jurisdiction of Bnss? So here options are prevention of cognizable offence section 168 to 170, prevention of injury to public properties section 171, inspection of weight and measures section 172. So here correct option is option D, all of the above are correct. Question number 550, the FIR can be quashed in the exercise of inherent powers by option C, the High Court. High Court have the inherent power for the end of justice. High Court FIR can be quashed in exercise of inherent powers by the High Court. Question number 551. Under the scheme of Bnss, the inherent power of rest in High Court. So here correct option is option A, the High Court. The High Court has the inherent power to raise the FIR for the end of justice. Question number 552. Once the police records information report, that is FIR, a copy of same should be given to the complainant under section 153 or section 173 or section 155 or section 156. So here correct option is option B, 173. Which of the following pairs are correctly matched? So here we have to match definitions with sections. Arrest to prevent commission of a cognizable offense. So it is given in section 170. So 1:4. Prevention of injury to public property is given in 171. So 2:1. Persons bound to conform to lawful. Persons bound to conform to lawful directions of police. So it is given in 172. Information in cognizable cases. So it is given in 173. The correct option is option A. Which of the following pairs are correctly matched? So information as to non-cognizable cases and investigations of such cases are given in, so it is given in option section 174. Report how submitted, it is given in option 177. Police officers power to investigate cognizable offense, so it is given in 175. Procedure for investigation is given in 176. So here correct option is option C. Which of the following pairs are correctly matched? Power to hold an investigation or preliminary inquiry. So it is given in section 178. Examination of witnesses by police. So it is given in 180. Statements to police and use thereof. So it is given in 181. Police officers powers to require attendance of a witness. So it is given in 179. Which of the following pairs are correctly matched? So medical examination of victim of rape. So it is given in section 184. Recording of confession and statements. So it is given in 183. When an officer in charge of police station may require another to issue search warrant. So it is given in 186. Search by police officer. So it is given in 185. The correct option is option A. Which of the following pairs are correctly matched? So here, procedure when investigation cannot be compelled in 24 hours. So let's leave this portion. The questions are not visible. Profit. Which of the following pairs are correctly matched? Inquiry by magistrate into cause of death. So it is given in 196. Offense triable where act is done or consequence ensures. So it is 199. Ordinary place of inquiry and trial. So it is given 198. Place of inquiry or trial. So it is given. Sorry, it is given in 197 and place of inquiry and trial is given in 198. Question number 560. When the police registered a case regarding to commission of a cognizable offence, the registration of the case is under section 173 of Bnss is the correct answer. Usually a copy of FIR is filed with the magistrate having jurisdiction to take cognizance by police officer in compliance to. So option B, section 176 is correct. A magistrate, question number 562, a magistrate not empowered by law is ordered under section 174 of Bnss is the police to give to investigate an offence or empowers the police to investigate the offence. Such order is option B, irregular and is protected under section 506 of Bnss. Question number 563. In a non-cognizable case, a non-investigation made by police officer without the order of magistrate under section 174 plus 2 of Bnss is an illegality not curable under the section 506 of the Bnss. So option A is correct. Once the magistrate has proceeded with the examination of complainant or decided to record the statement of the complainant on oath, options the police cannot be directed to investigate under the section 175 of 175(3) of Bnss. So here correct option is option A. If the offence was committed outside the limit of the police station, the officer in charge of the police station can transmit the FIR to police station having such territorial jurisdiction. The statement is true. Option A is correct. Question number 566. Any person aggrieved by the refusal on the part of an officer in charge of police station to record the information referred to in subsection 1 of the section 73 may send the substance of such information in writing and by post to the SP of the district superintendent of police. Question number 567. On a complaint for offence triable by magistrate after recording of statement of the complainant and the witnesses, if any, on oath. So option B, the police can be directed to investigate under section 225 of Bnss. Question number 568. Which of the following statements does not hold true for the confession made to the magistrate under the provisions of Bnss? Options are: it is the duty of the magistrate to exclude the presence of the police officer from the place where the confession is recorded. Option B, it is obligatory for the magistrate to warn the accused before his confession that he is not bound to make it and that if he does so, it may be used as evidence against him. Option C, the accused should be sent back to the police custody as soon as the confession is recorded. So option C is correct. Question number 569. on a complaint for confession triable by a court of sessions after recording the statement of the complainant and the witnesses on oath. So here correct option is option C. The police cannot be directed to investigate at all and the magistrate himself has to conduct an inquiry. Question number 570. In a complaint disclosing the commission of an offences exclusively triable by the court of sessions, so option C is correct. It is necessary to examine the complainant and all witnesses of the complainant on oath. Question number 571. What happens when any officer in charge of a police station receives an information that a person has committed suicide? Options are: inform the nearest executive magistrate about the incident as per section 194 of the Bnss, inform the higher police officer to proceed investigation, after holding an inquest finds the truth behind the suicide, all of the above. So here correct option is option A, informs the nearest executive magistrate about the incident as per section 94 of the Bnss. Question number 572. Delay in dispatching the FIR to the magistrate under section 176 of the Bnss. So here correct option is option C, may or may not be circumstance providing a legitimate basis for suspecting the FIR depending on the facts and circumstances brought on record. Question number 573, section 175 of Bnss. Options A, give the magistrate power to direct the CBI to investigate certain specific offences. Option B, gives the magistrate power to refer the complaint to corps of detectives, police for investigation. Option C, both and B. Option D, neither A nor B. So question number 5. So option D is correct. Question number 574. What are the requirements of section 175 of Bnss under which a magistrate jurisdiction to continue the proceeding cases? So here correct options are given. So the party against whom a provisional order has been made shall appear before the magistrate and deny the existence of the public right in question. Option B, the party shall produce some reliable evidence, example a record of rights or the settlement officer's receipt. The parties will produce evidence which shall be legal evidence shall support the denial. So option D is correct, all of the above. Question number 575. The court is said to have taken cognizance when it is. So here options are: orders investigation under section 175 clause 3 of Bnss, issues a search warrant for investigation. Options are both A and B, or option D, neither A nor B. So correct option is option D, neither A nor B. Question number 576. Which of the following statements holds true for section 225 of Bnss but not for Sanhita 175 Bnss? So here correct option is option B. The magistrate takes cognizance of an offence. Question number 577. The FIR gives information of the commission of a cognizable crime. Under section 173 of Bnss, who can give information relating to the commissions of a cognizable offence? So the victim himself, dependent of a victim, relative of victim only, any person. So here correct option is option D, any person can give the information relating the commission of an cognizable offence. Question number 579. FIR suggests that Option B is correct. It is the earliest and first information of cognizable offence recorded by an officer in charge of the police station. Question number 580. So here 580. In case of the information as to non-cognizable offence, the police officer is bound to options: only enter the information in his diary, only refer the informant to the magistrate, arrest the accused, enter the information in his diary and refer the informant to the magistrate. So here correct option is option D. Question number 581. Match list 1 with list 2 and select the correct answer using the code given below. So here options, and we have to match the list 1 2 with list 2 with the case laws. Duty to register FIR is given in case law of Rajinder Singh Katoch versus Chandigarh Administration and others. Latches in investigation, it is given in Krishna Godwa versus State of Karnataka. Faulty investigation is given in Saidu Muhammad versus State of Kerala. Delay in examination of witnesses is given in Surjit Sarkar versus State of West Bengal. Question number 582. Where the FIR discloses prima facie a commission of a cognizable offence, there is a delay in sending the FIR to the magistrate under section 176 of the Bnss. So here correct option is the investigation must go on. Question number 583. Permission to investigate into a non-cognizable offence can be granted by magistrate of first class in any part of the India, magistrate in any part of the state, magistrate having jurisdiction to try the offence. So here correct option is option C. Magistrate having jurisdiction to try the offence. Question number 584. The power to direct investigation under section 175 plus 3 of Bnss can be exercised by option A. A magistrate is correct. During the investigation, a search can be conducted without warrant by any investigation officer. When investigation cannot be completed within 24 hours, the alleged period for which can be accused can be remanded to a police custody is 15 days. Option B is correct. An investigation is not complete within the prescribed period of 90 days or 60 days, as the case may be accused is in custody or expiry of the said period. If he is prepared to and thus furnished bail, the accused is entitled to be released on bail by concerning magistrate. So here option D is correct. Question number 588. What is the maximum period of detention during investigation for offence of murder, after which and on non-filing of charge sheet the accused is entitled to be released on bail? So here option is C is correct. 90 days. 90 days is the maximum period of detention during the investigation for offence of murder, after which and on non-filing of charge or sheet accused is entitled to be released on bail. Question number 589. If the investigation is not complete within 90 days or 60 days, as the case may be, and the accused is in custody on the expiry of said period, the accused is entitled to be released on bail on making an application for release of bail is correct. Option B is correct. Question number 590. After the completion of investigation, the police is to submit a final report to the magistrate. So here options are is bound to by the conclusion drawn by the police and accept the same if the police recommended that there is no sufficient ground for proceeding further. Option B is not bound by the conclusion drawn by the police and may order further investigation. Option C may issue a process against the accused of the person. So here option B and C both are correct. So option D is correct, both B and C. Question number 591. After the investigation pertaining to an offence cognizable, the police files a cancellation report. The report can be accepted only by the magistrate. Option A is correct. Question number 592. Section 175 clause 2 of Bnss takes cares and cures. So here options are given. Any irregularity in the conducting of an investigation by the police officer, any illegality in the conducting of an investigation by the police officer. Here option C is correct, both and B. Question number 593. Under section 170 of Bnss, a preliminary inquiry into the commission of offence can be conducted. So options are by the magistrate having jurisdiction to take cognizance, by any magistrate subordinate to the magistrate having jurisdiction under the orders of such magistrate. So here only option A and B are correct. By the magistrate having jurisdiction to take cognizance, by the magistrate subordinate to the magistrate having jurisdiction under the orders of such magistrate. Question number 594. The powers under section 178 of Bnss can be exercised by the magistrate. So option B is correct, when the police decide not to investigate the case. Question number 595. The investigating officer under section 179 of Bnss cannot require attendance at a place other than the place of residence of a woman. Option C is correct. Option C is correct. Option C is correct. Question number 596. The investigating officer under section 179 of Bnss cannot require the attendance of a male at the place other than the place of his residence who is below the 15 years of age. Option A is correct. Question number 97. A trial on a police report initiated by the breach of the mandatory provisions relating to investigation. So here correct option is option B, is not vitiated. It is not vitiated and cannot be set aside unless the illegality in the investigation can be shown to have brought about miscarriage of justice. Question number 598. As per the provisions of Bnss 2023, an arrested person may be sent to judicial or police custody, and the case may be by the magistrate of second class if empowered by the High Court. Question number 599. How section 176 of Bnss provides safeguards for a victim? So recording of statement of the victim shall be conducted at the residence of victim or in the place of her choice is correct. The recording of statement as far as practicable must be conducted by one police officer in the presence of her parents or guardian, near the relative or social workers of the locality. So here both options are correct. So option C is correct, both and B. Under Bnss 2023, who shall record the information of rape being given by the rape victim? So one police officer or any. Option D is correct. Question number 601. During the investigation of an offence of committing rape, medical examination of the alleged victim may be done with the consent of such victim of any person competent to give such consent on her behalf. Question number 602. The prepositions are delay in dispatch of the FIR is not a circumstance that can throw out the prosecution prosecution case in its entirety. Delay in dispatch of the FIR is a circumstance that can throw out prosecution case in its entirety. The extraordinary delay in sending FIR in circumstances that provides a legitimate basis on suspecting that the FIR was recorded much later than the stated date and are affording sufficient time for prosecution to introduce improvements. Which of the following is correct in respect to the following aforesaid propositions? So here correct option is option B. 1 and 3 are true, 7 is false. Question number 603. Section 178 of Bnss empowers the magistrate to order a magisterial inquiry into a cognizable offence only in those cases in which the police decide not to investigate the case. Section 4. Under the section 178 of Bnss, the magistrate has power to option C here B are correct. Direct investigation by the police officer, depute any magistrate subordinate to him to hold preliminary inquiry. Question number 605. Under section 170 of Bnss, the magistrate cannot order an inquiry before submission of a police report. So that's it for today. Thank you for watching this video. We'll continue this series.